What happens to child support if the person ordered to pay dies? That's the topic of today's video. Hi, my name is Sean Palmer with the Palmer Law Firm, and I've been practicing exclusively in the area of family law for the last 19 years in the great state of Texas. And child support orders are obliging somebody to pay periodic payments for the support of a child until the child turns 18 or is otherwise emancipated. But what happens if the person ordered to pay dies in the meantime? Well, if you don't have anything special written into the order, then the child support obligation may end when the person dies. However, a lot of times you're going to see orders, and it's recommended to put it in there, that the obligation to pay child support will continue on after the obligor's death and will become part of the obligor's estate. So again, an obligor is the person who's been ordered to pay. An obligee is a person who would be receiving the payments on behalf of the child. So that seems like a pretty good way to make sure that the on and the child will not be sort of left high and dry if the obligor should die. But things can get quite complicated, as we saw in a recent 2021 case out of the First District in Houston. And the case is called Jackhart versus Jackson. Okay? And here's the facts. In 2004, husband and wife got a divorce, and they had a child. And the husband was made to pay child support, and the child support was made an obligation of the estate should he die. So years pass, and the husband remarries to wife number 2, and he has another child. Well, in 2016, he unfortunately dies. And also, unfortunately, he had not paid all of his child support. He owed a very large child support obligation, back child support, to his first child. And by this time, the first child had become an adult. When that happens, the adult child is now able to try to get that child support on their own, and doesn't have to go through the mother anymore. Well, sometime after his death, an agreement was made. There was a settlement agreement made that the son's child support obligation, the adult child's obligation right to receive child support, would be resolved by the sale of the husband's house. A $54,000 payout was expected, and so the adult child who was owed back child support was going to take that, and then the rest of it would be a wash. So this settlement was written down and signed, but it wasn't filed with the court until some time later. Now, nobody knows who actually filed it with the court, but it was. And then about a month later, the second wife, who in her capacity as the next of kin, and being that she was the executor of the husband's estate, filed a suggestion of death in the original court where the divorce happened and the decree happened, and said basically, the husband's dead and we need to move whatever's going on into the probate courts. So as part of that, the second wife joined all the parties in on this and said, hey, we're moving everything over to probate court to resolve the estate of the husband. Well, the first wife didn't like that. The first wife wanted to enforce the settlement agreement and wanted to do so in the original divorce court. And so she said that the transfer to the probate court was inappropriate. She said that the second wife had made an appearance in the divorce court by filing that suggestion of death, and that the settlement agreement should be enforced in the divorce court. Well, the divorce court denied the first wife's petition to enforce the settlement agreement in their court and said that it should be moved to the probate court. And then the first wife appealed that to the Court of Appeals, and she made two arguments. The first argument was that Under Texas Family Code 154.013, there is the right to settle out how child support payments are made, and the family court's authorized to enforce an order of settlement of child support. The second argument she made was that under Texas Family Code 153.0071, talks about how suits affecting the parent-child relationship can be resolved by mediation and arbitration. So based on those two things, she said it should have stayed in the original divorce court. So the Court of Appeals in the First District took this up, and they held the following. They said, well, 154.013, having to do with the child support obligation, doesn't apply because the first wife is living and the husband is dead, and so the obligor, the estate of the husband is the proper party here, and the probate court is the one where these things should happen. And the argument that the second wife had made an appearance in the court, therefore giving that court what we call personal jurisdiction over her, the court didn't hold, because they said that simply because the second wife filed a suggestion of death and sought to have that moved to the probate court, that doesn't amount to her seeking any affirmative relief from the divorce court. So she was never under the personal jurisdiction of the divorce court. And then as far as the mediation law, the 153.0071, the appeal court pointed out that the trial court never ordered mediation in this case, and further, the second wife was not a party to that mediation settlement at any rate. The second wife was the estate of the husband because she was the next of kin, and the agreement was just between the children, the children of the divorce, or excuse me, the children of the husband, now deceased. So that clause doesn't apply either. So because the husband's estate was never joined into any kind of action going on in the divorce court, that the probate court's jurisdiction wasn't challenged properly, and the Court of Appeals wasn't going to step in and say that the settlement agreement in the divorce court needed to be enforced. So a lot of different parties, a lot of different courts, and some complicated stuff in there. The moral of the story, I think, would be that yes, you can make the obligation to pay child support extend beyond the life of the person ordered to pay and make it a part of his estate or her estate, but it can get complicated in actually getting the money after that. And most of these cases are going to be heard in a probate court setting and not in the original divorce court setting. Facts may be different from case to case. So I hope this has been somewhat helpful. My name is Sean Palmer with the Palmer Law Firm, and if you have any questions about that, leave a comment below. And remember, we can't protect your heart, but we can protect your rights.